comment FT, like first time. FT stands for first time. We are also live on YouTube. Just waiting for a couple of other participants to hop in or join in. You can also feel free to unmute and speak as the participants. As we do not have too many participants, you should be able to unmute. Let me check. Okay, you have the freedom to unmute. Okay, Gopi Garu, thank you for joining in. So, sir will be here in a minute or two. Just spoke to him. So, just just going down the framework, I hope most of us are following us on our socials. Socials being the Instagram, Facebook, LinkedIn, and YouTube. Thank you, Gopi, for commenting FT first time. So, and today's topic is again IPR, intellectual property. Okay, good morning, everybody. Thank you for joining in, Gopi, Ramakrishna, Doc. So basically, I work on the marketing front with respect to content. Okay. So we've been doing this webinar series every Wednesday, mainly to create awareness in the startup ecosystem. Eeva Patent Services as a firm is helping everybody secure their intellectual assets. And we specialize in patent law, mainly the core team, our founder, Srinivas Madhipati Garu, specializes in patent law. So again, we provide expert advice services. The core team helps lots of businesses in protecting various innovative ideas through intellectual property. And we've been doing this for over 13 years now, represented 2,500 plus patents, patent applications at IPO, 17,000 plus trademark matters handled since 2012 officially. There are 6,000 plus patent searches conducted, over 25,000 patent illustration jobs conducted. So I'm just going through the glance of numbers which I have, which are also highlighted on our website. So mainly trying to help the startup ecosystem and MSMEs in India. So this entire session also is going through our YouTube live stream as a replay for the people who can't join in during these office hours. So over to you, Srinivas Madhipati Garu. So the boss of the bosses, he's my main boss. So we are trying to shuffle or probably keep things. Probably we are always on our toes, trying to help everybody. We are always a message away through all the numbers which are available through or all the socials. So just drop us in a message in case if you uh, face any query or if you go through any kind of confusion. So you should be able to share the screen, sir. I'll just stop share here.
Yeah,
So
please.
Gopi has joined in for the first time. I'm not sure about Dr. Anantaratna Kumari Garu. From which city you have joined in, Gopi? Is it like Telangana, Andhra, or Dr. Anantaratna Kumari Garu? Probably you can drop in the chat which city you have tuned in, because last time there was somebody from Chennai and just wanted to know which city you're from. Over to you, sir. Thank you so much. It's a beautiful new month, I should say. Yesterday, as it's Tuesday, we have Gopi Garu from Andhra Pradesh.
Thank you, Raj, for the intro. Thanks for the participants for joining today for the webinar. So there is a confusion between the trademark, copyright, patent, design, like the types of IP and what is the right IP for their intellectual property that they want to protect. So welcome to today's session. So we will deeply understand what trademarks, what are copyrights and patents are, how they differ, and how protecting them can build your business and avoid legal risk. Sorry. The slides are visible, right, Raj?
Yes, sir. We can see the screen. Why this matters, prevent, secure, and strengthen. Yeah.
Thank you. So many businesses unknowingly violate IP laws or fail to protect their assets. We will understand with more examples in further slides. So IP safeguards your brand creations and inventions from misuse. So enhances investor confidence and builds a strong competitive advantage. So it will prevent infringement risks. So it will secure your brand or creations or inventions. So and it will strengthen businesses valuation wise as well in terms of investor confidence. So what is intellectual property? IP or intellectual property refers to creations of the mind, inventions, artistic works, designs, and brand symbols, which are legally protected to encourage innovation and ensure creators benefit from their work. So the purpose is encourage innovation and creativity and to create a fair competition in the marketplace. And types of IP. So we are discussing in the title about trademark, copyright, and patent, but there are other forms. So designs of the is also an important form, and trade secrets and geographical indications. So we'll see a bit about each very briefly before we jump into differentiate between them. So focus today is actually we focus on trademarks, copyrights, and patents. So what each protects uh, and what is their duration with practical examples and why they matter in your business decisions. So that's what we will see. We will concentrate today. So we start with trademark. What is a trademark? So a trademark is in any sign, a word that distinguishes your goods or services from others. So it is your brand identity that customers trust and remember. You take FMCG products as an example, or pharma, the medicines that we use is an example. For that matter, any product or service. So we will have a word, a logo associated with the word, and there could, in some cases, there could be taglines or maybe the punchlines associated with the logo, and then in some cases, shape of the product, and also in there are other examples like sound and shape. Apart from shape, sound and smell can also be trademarked. So let us see. So what does it protect? A trademark, what does it protect? So it protects the brand names, logos, slogans, shapes, colors, sounds also, if distinctive. We have examples for sound marks registered in India. One is the Nokia tune and the ICICI Bank's jingle, the music behind the ICICI logo. We used to listen it in early days. So I'm not sure whether it is very popularly used today by ICICI. Anyway, so there are only few marks in colors and sounds, and there are no marks yet registered in smell, but the smells can also be trademarked. So word mark is a the Google the widely used by all of us. Google itself, Google as a brand name is the best example of word mark. To that matter, any brand name, only the name is the word mark. And the brands, when we are actually going for trademark registration, so we have to, if it is available and eligible, like if the word that we are coining for our brand name, if it is eligible and available, in that case, the word mark need to be filed, or it need to be registered as a word mark. Then it can be used in many forms. It can be associated with a logo. It can be associated with multiple logos to that matter, in case of a series of products with Google Chrome, Google something else. So Google Assistant. So in that case, it can be used if Google is protected as Word, then Google can use it for its lot of products and services. Let me go to the next slide. Yeah. So best example of logo mark again, we see uh, Apple's the bitten Apple logo is protected worldwide as a logo. So if any electronic company uses a similar logo, Apple can sue for trademark infringement to protect its brand image. And tagline, the best example for tagline is the Nike tagline, just do it. So Nike slogan, just do it, is trademarked. So if another sports brand uses this phrase, and it would dilute Nike's brand, and it misleads customers, then Nike can take an action. So in these examples like Google, Apple, or just do it, the Nike itself or Nike's logo, the tick symbol, all these are also well-known marks. So there is another concept of well-known marks, which means like after certain period of time, after they having registrations in multiple countries, and brand image wise, or maybe the search results wise, reach wise, if it is very popular, then the brand owners can actually ask the registries to identify their brands as well-known marks. And there are 100 plus brands in India identified or approved by trademark registry as well-known marks. So those marks, so I am talking about just do it or Nike in only sports category or apparel category class, but it's not like that. If the name is a well-known mark, if the logo is a well-known mark, or the word is a well-known mark, so those cannot be used across the classes. So across for all the products or services. Only those, for example, a mark is there in class 3 for cosmetics, being used by a company. If someone wants to use that name for a restaurant, they can definitely use. So because like that usage, or the customers of that brand in class 3 are different, and the customers of the same word, not the logo same, the word used for a restaurant, the customers will be different. So this case, which is not a popular brand, that case like two people or three people can use in different classes. Let me go to the next slide. This is the best example of all the marks or all the types of trademarks being registered by the applicants. Coca-Cola. So the word Coca-Cola is a word mark. The logo or the stylized writing of the Coca-Cola as a logo, device mark, and the tagline. I don't think like there is a tagline for Coca-Cola, but they have different taglines in different times. And the shape of the bottle. Here, this is another type of trademark. So shape of the mark, shape mark, or shape of the bottle, in this case, the Coca-Cola bottle contour is registered as a trademark as well. So this is another type of trademark. And as we are talking about sound and color marks, there are sound and color marks also. So I have given one example here, the Cadbury's purple for chocolates. So this has been trademarked in India. So Cadbury has trademarked the purple color. The patent number is 2685C for its Dairy Milk chocolates packaging, making this shade associated exclusively with its brand in confectionery. And if someone tries to use the closure shade of this color, so that will be an infringement. And we have sound marks also. The like I gave the two examples. So I haven't had a slide here, but there are sound marks also and smell marks. So apart from that, what is the difference in using it as TM or R? So TM indicates the trademark being claimed, and R indicates it is registered. So there is a difference. So normally people ask us when they come for trademark registration, when can we use it as TM and when can we use it as R? So we normally, or anyone practicing or uh, knowing about trademark, they say like after application filing we can use it as TM. So what is the cause or the bottom line behind? So it is trademark claimed. TM means trademark claimed. So, but it may not be registered. Even after registration, it can be used as TM because TM means it indicates it has been claimed by the applicant or the brand owner. And R indicates it is registered trademark. And the Trademark Act, Indian Trademark Act, specifically mentioned if someone is using R without registration, it is punishable under the Act. So they haven't mentioned about TM and when to use TM in the Act, but TM means it has been claimed by the applicant. R means it is registered, and there is a mention in the Act. R cannot be used without having a registration, and it is punishable as well. Because why I'm stressing on this, like we saw some brands, many brands, in fact, in last 15 years. So on their packaging, immediately after trademark filing or without even filing a trademark application for registration, so they show it as the logo and the label, the whole of the packaging, they show it with R, which is not correct. And why register? So, and what is the duration? So duration, trademark protection lasts 10 years from filing if it is registered, and can be renewed indefinitely every 10 years, keeping your brand secure for as long as your business runs. And there is, when we talk about copyright, we'll discuss about after trademark registration, copyrighting the brand, copyrighting the logo or the label, and what are the benefits. So it's the difference between the trademark registration as a device and renewing it every 10 years, and registering it as a word and then copyrighting the logo, so that like the protection, the duration is more without a need for renewing it as a trademark. So that we'll see in a slide.
Yeah, sir. Before we go to the next slide, could you please adjust your camera a little low so that, yeah, this is fine. Yeah, little some more.
Yeah.
Okay, thank you. And one quick question, sir. Now, these journalists which are reading newspapers on the touch panel or touch screen, now that you mentioned copyright before it skips. In fact, I thought I should call you and ask. So the quick question is, almost all these journalists who are reading newspaper live, Enadu newspaper, early morning, I see them on the Prabha or Andhra Jyoti or probably a couple of other newspapers in the morning for 30 to 60 minutes. I got to know few through our local journalists also. They are monetizing that live and also that content which is written by somebody else. Obviously, there is another offline journalist who had published that in the newspaper or news columns. But these people are reading it. So does it not fall under copyright, sir? Because I got to know they're making like 25 to 30 lakhs just by reading the newspapers. And somebody contacted me saying, I want to buy a touch panel. I want to read it. Does it fall under copyright and all? I told him, I'm not sure because anything which is published falls under copyright protected by the print company. So
Can you also research and let me know as well, our viewers, how many news channels or web channels we have in India and how many of them we have in other countries doing the same thing?
In India, there are thousands of them because starting from Tinmar Malana, who is doing, they have a Max Hub flat panel, and I got to know that Views are not VU. There is another brand VU, and there are lots of other flat panels which are all Google Android loaded. So there
It
are
is not.
thousands of them. Everybody
Yeah.
is reading mainly with the vernacular local languages, newspapers. They're all reading or just flipping those 30 to 50 pages. I'm sure there will be a major case in case if I do the same thing with Times of India or with Deccan Chronicle or with the Wire, because Wire itself has got blocked when they were writing or doing some things against Narendra Modi. If you just Google Wire as a print media or as a house, they got banned in India. In fact, the Wire.in was not available throughout Indian region. But again, they went to Supreme Court, filed something, and they were calm, is what I got to know. So, so back to the same questions. There are thousands of them doing it. So, as per research, in India or in Telugu states, we know thousands of YouTube channels exist. Of the thousands, there are hundreds of them who are famous. So, does this not fall under copyright law, sir?
That was a very good question. So this slide itself, what I'm scrolling back and showing you. So I'm showing this Coca-Cola bottle for making you or the participants understand about the trademark and copyright registration and the difference between them. So this bottle is copyright image of Coca-Cola, and I'm using it for my publication related to, maybe it's not commercial, but it can be commercial also. So maybe I'm publishing or maybe I'm running this course and I'm charging something to make you understand about the trademark and copyright. That means like I'm using this image without a formal consent from Coca-Cola for my commercial benefit. So this is not completely wrong. I mean, and as well, it is not completely right. So what I mean to say is so Copyright Act will give authorship to everyone who does something. Means like if you translate something into Telugu, reading an English newspaper, making Telugu readers understand, or reading Telugu newspaper itself uh, uh, in the morning, as you are telling, by a channel, by a web channel, and making the viewers understand the news, the lines behind, or whatever in between. So the meanings and all in his own with his own opinion, obviously. This is something he's generating his own authorship with his own content using the existing works of others, the newspaper of Inadu, the publication of Inadu or Andhra Prabha or Andhra Jyoti. So normally as per Copyright Act, they need to have a formal consent taken, not every day, but at least like we are running this program every day morning. So we'll be taking the newspapers of, of all of you to actually generate a content. So that formal approval need to be there. If they like, if Inadu wants to want some channel not to read their newspaper and interpret it wrongly, if they feel they are doing that way, then they can definitely summon them or serve a notice asking not to do. So that
Okay.
right is there. So it is not completely right or it is not completely wrong. So the
Yeah. End of
great
the day, they're
author is
showing
like,
that.
yeah, the content we are generating now or the whatever we are speaking in reference to all these brands. So this is our own content, definitely. So we will have this ownership. So if it is non-commercial, there is no need, like we need to have a formal approval from them. And if it is commercial, yes, definitely there need to be a formal approval. That is correct. That's why I asked like how many channels you can see in other jurisdictions and when compared with India. So there is no formal law, or maybe people doesn't follow the law 100%.
Now,
That
the
would,
loophole here is they're saying they're doing it for free, and they're saying, okay, look at your .com, your web domain, your website, your newspaper, and obviously they're not selling their live, but through YouTube ads, they're generating it. So, and the people who got silver play buttons, a couple of guys whom I know who had reached 100K followers, I cross-checked with them also. They said they never got a copyright law for just reading public content. So, and with the news, Google News and Trends, I thought probably I should be doing the same with the
you can cross check with BBC or maybe Inadu itself. So whether they do this, they won't do.
PTI, the Press Trust of India, or I mean the content which goes on to their
If
YouTube
they
channel.
does, if they does, they'll give credits to, like, if they ever take a video or image or maybe something need to be shown along with their story, they'll actually give credits saying like this is from so and so source.
Yeah.
That need to be given, but these people won't give that. So if they can actually scroll a disclaimer saying like this is the source and this has been taken from so and so source, then there is no issue. Some
Okay.
some channels will do that. The formal
EN, yeah, ANI news
standard
channel,
channels.
they blocked, they demanded 50 lakhs or 1 CR for a 5 to 6 second clipping which was used. That's also a major news.
Yes.
Thought I should publish that under copyright, but okay, we can continue with the flow, sir. Now I got the clarity. So the disclaimer scroll or probably telling the, okay, we give the credits to the original owner and orally saying and accepting. Okay, cool. Thank you so much, sir. I got the clarity.
So the previous slide, actually, we are talking about why registering it formally in terms of, or in the case of trademarks. So registration makes enforcement simple and builds brand credibility. So means this sentence says like registration is not mandatory. So trademark or copyright, anything, uh, it can be used directly. We can publish. We can do business out of it. Registration is not mandatory. So Trademark Act or Copyright Act says like doesn't say registration is mandatory to. It's a license. So it's not a license. So, but registration makes enforcement simple. So we can, without trademark registration, we can go to police station and say, give a formal complaint saying like, I'm using this brand so and so from so and so, and we can say, give evidence of the probable infringement, and then the common law will take care. Actually, they'll get a protection under common law. But with trademark registration, the formal registration, the enforcement will be simple. Means like the police station will know, yes, it is registered, and this guy or this company filed for a registration and they got it, and he can proceed further. Not to take some time to investigate whether this complaint is true or not, whether his credentials need to be validated or not. No need this all this jargon. So registration makes enforcement simple and builds brand credibility. Customers also trust registered brands more than unregistered ones. Obviously, they don't know. It is not that easy to search in the customer point of view. It is not that easy whether this brand is registered or not. They cannot search very easily with the infrastructure that is available today. But yeah, if that is also available with an app or maybe very easily as we search on Google, even if the trademark registry, the global registry we have by the WIPO patent scope, or the WIPO's brand registry search, but Indian trademark search is not that very effective.
We should run a campaign also, sir. Do not do business with unregistered.
Yes, yes. So, and this is what it does not protect. Means example of a misuse, or maybe it does not protect the product's technical function. What cannot be protected under trademark? So that is the slide. And it does not protect the product's technical function. The technical function, it goes as a patent. So the brand or the image or the packaging, the style, the logo will be registered under trademark. and any artistic work or related work, the marketing material, these things will go as copyright, and the functionality of the product itself cannot be trademarked, but it can be patented. And we'll see an example of misuse. Obviously, if someone is selling a phone using the name iPhone, or similarity of an iPhone, saying like B phone or T phone, something like that, with the same packaging or maybe style of writing. So that will be an example of misuse.
If somebody launches a new brand saying U phone or T phone, sir, they can't, because phone is a generic term, right? It's a descriptive and generic term. So can they not launch another brand just with another letter, another alphabet?
We have T-Mobile, one brand of T-Mobile is a service provider of telecom services, but they have their own brands also. So T-Mobile is different when compared with iPhone. But you can see there are no U phones or V phones or T phones, because yeah, iPhone or Apple is very strong in actually protecting their rights. So otherwise, yes, you might have seen a B phone or U phone.
Geophone is there, right? Geo, they don't call Geophone, but they just call Geo.
Yes. Yes, we can have a T phone or U phone, but again, like the other person, like the Apple, if they are very strong in actually protecting their rights, so they won't allow us to penetrate into market, and they'll remove the. If ever someone tried also, so we can search. I never searched. This was a very good example.
Because phone is a generic term, because the same thing
Phone is
goes with.
generic term, and iPhone is also is not that very strong word mark to be registered, because it only an addition of I, and but they have a series of I addition to iPhone and iPod and iPad. So in that category, Apple iPhone, Apple iPad, Apple iPod. So these are the series marks that they actually started putting to the trademark registry in US and then in other countries also. And also they monitor or watch the trademark registries across the countries. Also watch on internet whether someone trying to misuse, and they will be very strong in that front, so that like we cannot even get that results. Someone should have tried, but I don't think like they are very successful with that.
So, to register series of terms are like Eeva trademarks, Eeva patents, Eeva copyrights, like that. Do we need to have multiple applications filed, or just the
Yes,
name, the
there is a
word
type of
mark?
application, a series mark. So for this case, this is the best example. Apple is the word mark, Apple is the brand, and Apple iPhone is the sub brand, or a product under Apple. So Apple iPhone, Apple iPad, Apple iPod. So these are the series marks can be registered with single application. Means like the fee need to be paid anyway for each application, each sub application. But application wise, we can file one application.
Yeah. I remember the other word series mark like Mallareddy Dental Sciences, Mallareddy Pharma, Mallareddy Engineering College. So with the
If the
name
same
Mallareddy.
logo, yeah, in that case, if the same logo is being used, but only the subdomain, means like the variant of their institutions, then they can definitely file. Yes, and the best example comes for series marks in the category of seeds, fertilizers or seeds. Like they'll be having XYZ K40, XYZ K80 or 70 something, K40, K70, K80, or 200 mg, 500 mg. So these are series marks. Or if someone is branding their clothing as SM, between small and medium, there is no category. There is a category of excess, extra small, small, medium and large, and extra XL and double XL. But if someone is actually maybe trying to put in between, so SM, ML,
Okay.
LXL or some LX or something like that, then they can actually come up with their brand name, and maybe if they want to name that or make it popular as SM or ML, so then they can actually file a series mark trademark application.
Even I was wondering about the same, like yes bank. The word yes is so common. You say yes, tell me, yes, tell me. But again, yesterday I was thinking about the word yes. How did they get the brand? I mean, how did they get that registered? Just it's a common term. Now they are positioning themselves and all, but again, it's an endless series of questions with the common name, common phrases. Yes is just a basic name. I don't know if yes stands for any full form, but as a bank, they're surviving and they have opened a recent one here.
Yes.
There you go, another yes, but that's a brand. Oh yeah, let's continue, sir. Thank you.
And the common mistakes in trademark registration, like businesses often register logos. Even the trademark attorneys in our fraternity, or maybe the chartered accountants or company secretaries. So without knowing the difference or the importance of word marks, they normally suggest to file the application as a device. That means device means the logo itself is having the word in a stylized writing, and the logo may have some kind of an abstract representation. So what this device application is actually telling, as per Trademark Act, as per Trademark Office, is like we intend to use this brand name this way. So that means like we are confining ourselves, saying like we are limiting our chances of using maybe like Nike. They use it as just a symbol. They write Nike, just Nike in text in that slanted font. Or they some places they only write just do it. So without having a word mark for Nike itself, so we cannot have this flexibility of using our brand in different cases and different scenarios. So registering only a logo, but forgetting to register the brand name as a word mark if it is available and eligible. In cases if it is not eligible, like iPhone, it is not eligible to file as a brand because phone, only a letter I is added to the phone, and obviously the product is phones. So that is an ineligibility. Means like you're not having a unique word or a coined word for your as your brand. You are only describing, or it is very suggestive. iPhone is very suggestive what the product is. And there are many examples, Make My Trip, Book My Show, initially when they coined this as their brand. So it is very suggestive, very descriptive. So they are not eligible as word marks to be registered initially when they started, but after their market capture, market share, and after their popularity, after their penetration into the marketplace, so they are eligible as to file word mark applications also and getting registrations. But if, yeah, that's what. If someone is coming up with a brand first time when they are starting a business for, for some product, and they want to register a brand, if it is eligible and available both, then they have to get it registered as word mark. There is no need like logo need to be protected at that point in time, because like by having word mark registration and by publishing your brand on your product, you'll obviously get the copyright protection. And after some time, after registration of this trademark, we can actually file it as a copyright for a registration, or we can file a logo application separately, the second one, for registration of the logo. So with this, like they'll get 100% or 200% protection for their brand name. And this thinking of having one in two, having two in one application, that is not correct. Two in one application means like device application doesn't mean it is word mark application as well, logo mark application. It is one application, and we are confining ourselves, saying like I'm using it this way, and it is not confining, but saying like we are using it this way. And in future, if we ourselves want to change our logo, then yes, the earlier application or the earlier registration of is of no value. So we need to file one more application. And we'll come to see
And
some
quick
more examples.
question, sir. Quick question, as in, do we need to file? Because the theme of today's session was like with the Lego blocks which we put in, does everybody need to file patent, copyright, and trademark of the brand? Because startups, do they need to file all three, or just one is enough for a beginner? Uh, is it all mandatory? I mean, all the three applications mandatory.
It's not three mandatory for each of them. Like it is something like that is the session. Like we'll conclude understanding all of these. So we till now we discussed about trademark and we'll know about copyright and patent. All of three are not applicable for everything. Means like for the brand name, patent is not applicable. So patent doesn't cover. Patent is for the utility part of the product.
Yeah.
Means the working part of the product or the technology part of the product. And copyright is for the artistic part of the product or the label design, the brochure design, the video shoot or the video ad of the product, the audio part of the product. Means like the Nokia tune or some tune for our brand name. These parts can be protected under copyright, and the name part and the logo part can be protected under, again, logo part can be protected in both trademark and copyright. And the label part also, label of the product itself, it can be protected in trademark as well in copyright. The shape of the product can be protected in both, like again in trademark as well, and as well in design registration. So there are some combinations why we will discuss, but apart from this, like the title clarification, trademark is for some part of your IP, and copyright registration for some part of the, or some the other part of the your IP, your work, and patents are for something else, like for the product working. But the question, like the bottom line is like you need to have a registration for whatever IP that you have. So without having a formal registration and going into market, and if you after maybe 2 years or 5 years or 10 years, even after 10 years, there are cases like there are brands in Hyderabad who are struggling now to stop infringements because they don't have a formal registration, though they are very popular brand and they have usage from 10 years in Hyderabad and in two states, but they couldn't actually bring down a false listing or maybe a listing which is having the same name of their name in Zomato or maybe on Amazon, and they're struggling for maybe more than 1 year or 1.5 year in some cases to get that done. So with formal registration, they can get that done in maybe
Quickly.
few days, 1 week, 2 weeks, by registering a complaint, showing our registration certificate, a certificate copy to the SHO, who is obliged to take a complaint and do a formal investigation and register an FIR. If that happens, obviously the other party will come for a settlement. They'll stop to use, and then they'll close. They'll surrender everything what they have. They'll sign a declaration saying like they won't use it further or they won't try using it further. So this happens with formal registration in hand. Without registration, it will take years. And then, yes, you know what happens. What happened with, we cannot name, maybe we are recording. What happened with the popular biryani brand in Hyderabad once 20 years back, and what happened with a popular a coffee shop or maybe a tiffins segment in Vizag. There was a very popular brand, so which has been diluted now today. So we can see with the prefix added to that name uh, everywhere.
Yeah, most of these legal battles which are going, they're there either under live law or under news section. If I Google the same brand, like this biryani brand or the couple of, there are legal battles and there are news. If I search with some brand name, or probably if I search legal battles of the brand biryani, this will pop up. So as they're already in public domain, I guess it's absolutely fine, because we are not monetizing this directly. We are just creating awareness, or probably we are trying to educate or add in our knowledge and expertise to the community, I guess. Should be safe there, but you're the attorney, you know it better. And also, I got to see this, sir, before we jump into the copyright and the next segment of the section, as we have 15 minutes, as we have few participants who joined in a little late. So the other quick one is like I saw this Suman TV are probably interviewing this solar bike. So there was this guy from the old city who designed solar bike, and he says costs only less than 100 rupees like per week uh,
Come
to for the fuel or for managing
on.
stuff with respect to uh, so that 100 rupees of it's saving lots of fuel for him. The way he designed is just the panel, solar panel on the top of the bike with the battery and the handle. He says it's all his idea and designing, but he's not protected, right? So legally, the design is not protected. He doesn't have a brand. Anybody can do. It's a jugaad setup, but he's doing it at a bare minimum of less than 10,000 rupees converting. And now that with the monsoon and rains, when there is no sun, how does the bike operate? Obviously, it has the fuel also. Um, but again, I wonder how they survive. I mean, they're basically for the initial setup and installation. So we have Dr. N. Anusha who joined in, and Swati who joined in, Kazi Munawar also. Thank you for joining in. Just put in the chat if you are here for the first time. Just type in the chat FT, or if you have any questions also, feel free to unmute and ask. Uh, Srinivas Garu from Eeva will be able to answer it as we are going with the flow. We have done this hundreds of times with the same presentation at multiple places. That's the reason we are giving the freedom as the number is low. We are giving the freedom to unmute and ask. So over to you, sir. Thank you.
Yeah, we'll quickly discuss about copyright. So what is copyright? Copyright protects original creative expressions like books, music, films, photos, and software code, giving creators control and economic rights. So I mean original creative expressions means like it can be a translation also being treated as original with proper credits to the earlier author or a formal approval from the NOC from the author or a license from the author. We are discussing about the videos or the web channels, like discussing the same news being published by some sources initially and then discuss as videos. Obviously, they'll monetize, so they have to give credits to the sources. So that is one thing, the minimum thing that they can do. If not, like the original publishers can actually ask them to take down the videos, or maybe they can also file a suit on these channels for the habitual or maybe reputational kind of usage from months, years or so. And copyright protection actually gives automatic protection, means like because of the nature of the works. So we are talking about books, music, films, photos, or the newspaper itself as a best example. Inadu cannot actually file an application at 12 a.m. every day and then publish their next day news. So for that reason, I mean, Copyright Act doesn't mandated, I mean, didn't mandated registration for giving protection. So copyright is automatic once an original work is created in tangible form. So this is more important thing. So tangible form, it can be an email also. Nowadays, it is tangible form. But at one point in time, the tangible form is physical publication. But now any publication in any form communicated electronically also is a tangible form. So registration is not mandatory, but registration for certain things like the software code or the book or the music before publication or the films, the all of the films that we see, if they can actually or before production of the film, for example, a story writer, if we can actually file a copyright application before even registering it, his title with the movie association or whatever. So if they can actually protect by filing a copyright application, which costs only 500 rupees, the government fee as literature work. So it will protect their interest, and we see a lot of uh, disputes between the original writers and the production houses. We already saw some, and this is a everyday thing. So for popular movies coming up, for the popular titles, so though they have a formal association to register their members' works in a formal register by paying some fee, the movie associations, but it is always better if they can resort to the copyright protection provided by the Indian Patent Office.
Yes, sir.
And examples of books, we all know Harry Potter books are copyrighted by J.K. Rowling and his publication houses. No one can legally print or sell copies without their permission. And example of movies, we know RRR is protected under copyright, covering the script, dialogue, songs, cinematography, and the film as a whole as an audiovisual work. So before that, Bahubali they didn't do. Um, there is no issue for the movie as a whole, though there is piracy thing we all have. But apart from the piracy, the brand name, at least Bahubali, in Bahubali case, like there are many misuses in classes like class 7, which are for machines, and class 6 for maybe for the iron and steel. Uh, in these classes, the Bahubali is the right word they felt after the movie, the version 1. And then there were, I mean, the Arca Media, the production house has to file trademark applications, and then they has to send cease and desist notice to these users who file trademark applications also. We can search and see the results. Even today, like we have like more than 40 results, I guess, in these classes with Bahubali, with Arca Media as well, filing and getting a registration, and then other people also try to register it as a brand for different products. And music, obviously, all music composed by A.R. Rahman is copyrighted without a formal registration. Also, like he'll get that copyright protection automatically on publication, and some of the works like he filed formal applications for registration also. So if someone wants to use his works, then they need to license to reproduce, or license to remix, or use them in films or ads. So this is what copyright protects. And other examples of photography, we can see wedding photographers who own copyright on their photos, but clients get usage rights. But commercial printing or publication needs their permission. So this is one thing, like it will define the copyright, what is copyright. So wedding photographers own copyright on their photos, partly part right, and part right is the clients, and the ultimate right also with the clients, because if they want to reproduce, like they have to get a permission from the clients. So some photo studios, olden days, now like we cannot see photo studios also very often. So they'll publish some of their client photos as samples in their studio. So for that also they need a permission from the client. Though obviously, I think like they'll take, and in some cases maybe they should have not taken also. So this that is another thing. And another example is of software which can be copyrighted. Code for an Android app. The source code of apps like Paytm is protected under copyright, and preventing direct copying by competitors. The flow, the images, the content of Paytm is not the same of PhonePe or some other payment app. So the flow is different. You can compare with Amazon and Myntra, or maybe some other marketplaces, or Flipkart. The flow will be different. The buttons, the menu bar, or the checkout, where it actually positioned on the top or on the bottom, on the left side, on the right side, everything will be different, because like the first creator, maybe in the case of marketplaces, if it is Amazon, their layout is their right, and no one can actually replicate it. If someone is actually planning to develop an app, a marketplace app, or maybe some other application. So don't rely on the free layouts, or maybe the app layouts, or the templates. So it should be customized for your need, because this free layout, someone should have already adopted and filled with this content and images. And if you compare after your production of your app, so if you compare both, the layout will be same. So there will be a conflict without knowing or unknowingly, which is being created by your developer. So this care need to be taken. So these are the examples, and what it does not protect. So what copyright does not protect. Copyright doesn't protect mere ideas, methods, or concepts. So people come up with ideas saying like, I want to patent. So we often receive these calls saying like, I have an idea, I want to file a patent. It can be neither filed as a patent, it can neither be filed as a copyright, it can neither be filed as a trademark. The name, if they have some name in their mind, yes, it can be filed as a trademark, but the idea itself cannot be patented or copyrighted. We can file, but anything can be filed, because like on filing, so the module, the IPO module, patent office module doesn't stop you to file. So anything can be filed. An existing thing, just converting a PDF to Word, you can upload. But it doesn't mean like it allowed you to file. It doesn't mean like you'll get a right. So copyright or patent doesn't protect mere ideas or methods or concepts. So it should be some implementation of your idea. Like you had an idea of generating power by multiple sources. This is an idea, and multiple sources can be a solar, and the power stored in a battery, and then again battery giving power to a wheel, or maybe a motor, and the motor on braking, if it is a motor of a EV vehicle, the motor and during the drive, on braking, the braking inertia, or the whatever the regenerative braking concept, will again power the um, battery. So this is a 360-degree cycle. So the inventor may think of, actually this is an idea, but yes, it is a patentable idea, but the implementation part, how it is been, how it is happening, what are the components, what is the construction, and what is the efficiency that you are actually getting, what is the power that you are actually receiving on the road in different conditions of weather, and how much power it is being, the solar panel associated with the body of the vehicle is generating, and how much is it is being stored in the pack of batteries that you are having, and then how much is being used for maybe for 10 kilometers of drive. So what is the power required, and how it is being managed by your the power management system within the whole apparatus. And then what is the regenerative braking is generating, and how you are actually giving it back to the battery. This whole concept need to be visualized, tried, sampled, tested, and then results compared with the existing ideas. This idea, the base idea, like there will be other people also having this idea, and they should have published papers. They should have had some companies should have had a product like this. We need to compare with them, and the improvement part can only be claimed as a patent application, and the text or the code or the design, these parts can be protected under copyright and design, but not the idea itself we can patent, or not the idea itself we can copyright, so that like we'll get enforcement rights. We can file a copyright to create an evidence saying like, I had this documentation of this idea. We can file a literature work application with a government fee of 500 rupees for even for the ideas also. But that doesn't that registration of copyright, because the copyright office doesn't do a validation of what we are actually submitting to them, because of the nature of the work. Copyright work is a artistic work. It cannot be searched in internet, compared with others, and say like it is new or not. So for that reason, Copyright Office doesn't do validation of the product that we have in trademark and patent applications.
So quick one, sir.
Yeah,
So there was this 15-year-old Filipino student who created that mobile charger from his walking shoes, right? As I saw that
yeah,
it became so viral and I had to publish it. Many people were sharing it. So if another Indian student comes up with the same idea, and there were amazing comments also where people like, I've created a trouser or a pant which has anti-radiation kit or something like that, and people were comment is full of ideas in this one particular viral post. So, is that possible in another country when somebody had come up with it? Again, can Indian students take up that project and create something like that? Because we know we have power banks, but I don't know if just by walking shoes we can generate that energy to charge up a mobile. So, can they file patent or there should be obviously a product or probably the testing and all that.
very
With
good
the
question.
with the
Yeah,
idea, can they launch it again?
very good question, Raj. Actually, the Philippines, this person had this idea, and if it is new, and the construction part on and the generation part is also been validated, saying like validated to power maybe 10 mAh or maybe whatever 100 mAh or 400 mAh battery, then that part he can definitely, or that technology which is not there till now, or the construction part uh, into a device which can be inserted into that shoe sole or whatever. So can be patented in Philippines and and as well in other countries. But it's up to them, like they file in other countries or not. But the Philippines application, the publication of the application will become a citation for other people to file a patent in other countries. That means like our students, we had this, I been demonstrated in Malareddy University last year. So they had this kind of piezoelectric sheets been draped or like fixed to the staircases in the college, and it's all connected to a power bank obviously, and when people are walking on the staircases, so it will generate power because of
Wow.
the piezoelectric cells are known, so that is there from many years, and some countries they tried on roads as well, on pavements also. So this power generation is known. So this person actually putting it into the shoe sole, this is unique thing which no one else taught, and this can be patented, and he is eligible to patent in other countries also. And people in India, for example, some student from a college in India, so he can also adopt or take the technology, and then he can develop a product. If that person is not, he doesn't file a patent in India and he got a right in India, this person in India can actually prepare a product, manufacture it, and sell it in India itself. He cannot export to other countries where the other person had a right. So this we do normally. This is called freedom to operate search. All the products, all the companies, all startups, while they validate their product, they have to conduct this freedom to operate search. That means like their idea, what is their plan of actual implementation, what is the cost that they want to sell, all these things like documented into one thing, and they can have a freedom to operate search. That means like this search will validate whether this idea is been published somewhere else or not, and in what form they published, whether the product is already there or a service is already there, and if they're whether that company has a right in India or in whatever jurisdictions that we want to use this, so whether they have a right in India, that countries or not, that we will validate. So we won't get a protection for the taken or copied. We cannot call it as copied. We can definitely operate in other jurisdictions, the same thing which has been operated in other the source jurisdictions, but with either with the permission of them, or if they are not interested in our jurisdiction directly without having a permission. So both are legal.
So there's no crime in having the idea. Like I was thinking about why not the footfall where the railway bridge or probably the railway corridor or steps where there is lots of footfall,
Yes.
probably they can generate more energy. But so I guess we should run a campaign there also saying, I mean, going through ideas is not a, or having ideas is not a crime. Lifetime of author, 60 plus years. Okay.
Yeah, duration of copyright registration in India is copyright lasts for the life of the author plus 60 years. This is in altogether indefinite protection. Like the life of the author or uh, the the time period of duration of the firm or company's existence plus 60 years after the company cessation or maybe after the death of the inventor or the author. So ensuring long-term income to heirs as well or the company which holds the copyright protection. So this is the other aspect what I'm talking about registering a logo under trademark rather renewing it every 10 years. After registering it as a word, we can register the logo under the Copyright Act so that like there is no need of actually a renewal going every 10 years. Anyway, like the word will be renewed and the logo protected under Copyright Act. But to protect a logo under Copyright Act, if it is associated with a logo with a brand, then the condition under Copyright Act is like it need to be protected as trademark first, and then the applicant need to come to the Copyright Office saying like I have this trademark registration for the word and the logo I want to have protection under Copyright Act. So that is a mandate. And the common misuses we see using Google Images or for websites or marketing without permission is an infringement, even if easily downloadable. So that is an offense, obviously under the Copyright Act. So again, fair use. There is a concept of fair use under Copyright Act. So for what you are using, whether you are selling this image as well along with your content, means like if you are preparing a book on Copyright Act or maybe Trademark Act, and then having all these Apple logos, Google logo, as well all the things that I'm showing today. So and I publish this as a book and I'm selling it for 100 rupees. So that is a this is gross misuse without their consent. At least like they're also the same thing, fair use. You mentioned the source, say like this has not been your thing, and this has been actually of so and so company. For understanding purpose, like we are disclosing this in the or we are showing this in this slide.
So when we say source Google, does it also cover all the other websites when we
No,
say?
we have to give their individual source. So we
Okay.
search on Google and we'll get different links of the websites. So we have to give credits to the original publisher. So we
Because
have to
on
search
YouTube also I've seen
the
lots
original
of,
publisher.
yeah, on YouTube I've seen people talking about Jim Rohn, Tony Robbins and all that, and they give source as YouTube, uh, which is again I see them recirculating on LinkedIn or Facebook, but the source will be mentioned only as YouTube. So I guess
You
maybe.
know, like we have tools today like ChatGPT. So we can either combine the text into our own content. We can rewrite the content, but still like we can again get the sources also the original websites. We can search through their websites and then we can give a note of what we have done. So that is a formal way, right way to do.
Yeah, sure, sir. So for other participants who are still in Gopi Garu, Sarita Kumari, Gnana Sarita Kumari Panga, if you have any questions, feel free to unmute as we are already running out of time. Swati, the other participants are our staff, I guess. Anybody, any questions, or shall we continue with the flow? Okay, the next is enforcement.
I
Uh,
have actually
how
two
copyrights
questions.
can be enforced? Yes, sir.
Yes, sir. We have a
Uh,
question.
yeah, hi, Srinivas sir. Um, Actually, the question is related to the patent application. So
Yeah.
it is protected for 20 years. Let's say I have a conflict question, like let's say somebody is applied for a patent in India and it is granted for 20 years. Now, let's
Okay.
say consider 2021 one. as the date of application, and from there he got around 20 years protection, right?
Yes.
And the conflict is, let's say if somebody in 2024 have some extension to the product. Let's say functionality one is covered in 2020 application, and 2024 he has come up with let's say the functionality two. Now the final one should be like function one and function two can be work together, and maybe get some advantage out of it. Okay, so in that case, let's say if it is manufactured by third party, um, should he take two applications enforcement right, or only the second one's right is fine to manufacture? That includes functionality one and functionality two.
Very good question, sir. It is again like case to case, but yeah, the answer is within your question itself. Like an NOC for a manufacturing company is to be taken from both the parties, or royalties need to be shared to the both the parties for working of the patents. So, but this functionality one and two, if you take a very good real world example, then we can properly understand why we need to pay royalty to both the parties and why not. In some cases, I'll take an example of EV vehicle, and we already discussed that example about the regenerative braking. If the company wants to, we know already EVs, we know solar powered or maybe other fuel powered, means like hybrid model of the EVs also. Like it will have petrol as well, and it will run on battery, and there will be a battery management system or the power management system where it switches between. There are other control aspect also, which where it will switches between petrol and the battery. And now, if I want to add regenerative braking, and I want to manufacture the vehicle as a whole, which includes petrol variant combined with the battery variant, the same BMS, and same other aspects of controlling between the powers. And then I want to add this regenerative braking. So my invention is only regenerative braking. I want to work with, I want to work this invention, then I have to work with the existing presently protected under Patent Act, maybe by a couple of companies, maybe the brand by Honda or maybe someone else. So if I want to work the invention in the way that I wanted with the recent or latest running model, then in that case, obviously I have to take a permission with Honda from Honda. If as an example, if they have this technology, or if I have to give the technology to the Honda for a royalty, so that like this regenerative braking can also be added to the existing their model. Yes, right? So in other cases, maybe functionality one and two will be different. So where like both are very close. This example also it is close. Like I have to work with functionality one if I ever want to roll out a product along with functionality two, right? So
Yes.
case it is different, but in other cases it can be a method improvement. In cases of chemistry, pharma, or maybe. mm, I mean, filtering or maybe treating some material or something like that. So in that case, there is a method already known, which is patented or maybe under the patent protection time period. But the method, what we are proposing, though the initial steps of cleaning or whatever, preheating or whatever is common, which is known before before the first patent also. Then in that case, like we can skip the in between patent right holder, and then we can work on our own, because the preheating or pre-cleaning or whatever, that steps are already known before him. And then whatever we are proposing is totally different from the core aspect, is totally different from what they are actually having. Then in that case, like we can work independently. So that while drafting our patent application, it is where we should be very careful. We are not falling in their bucket. We should be drafting our claims, eliminating or showing those steps as known steps, which are also known for them. And we have to write the claims, the steps in our the inventive steps in the second part of the main claim as a whole, which are very new, which we wanted or which we developed. With that, like we can, with the patent grant itself, patent document itself, we can exclude this party, not in our bucket, from our bucket, and then we can independently operate or market or manufacture our product.
Okay, so excluding the other party, like if someone is given the patent right for 20 years, right? So the obvious idea we cannot, exclude it. Like there might be chances, okay, not striking out. But yeah, if we can exclude them in a way, then we can exclude it. Otherwise, we have to pay the royalty to the functionality one as well if we can't avoid it.
Yes, yes.
Uh, yeah, there is one more thing. Like one hour application ended up with the grant. Okay, there are applications ended up with other states, like maybe refusal, or maybe someone has just published and not taking any action, so that they are deemed to be abandoned, like they are not moving ahead with the application.
Yes.
Okay, so the effective date is like the application whenever he or she filed it, right? And let's say in the later stage, if it is protected 20 years, that is one case. If it is open to public, let's say one is withdrawn the application or maybe rejected the application at that stage, uh, what happens if somebody after 10 years has come up with the idea that is overlapping with the abandoned application, uh, or maybe the application didn't go through all the stages of it.
Yes, there is always a chance, like even the granted applications, granted patents, or the published applications which are not through the patent grant, so they might have disposed as abandoned or refused, or been withdrawn by the applicants themselves for some reason. The patent office, the examiners of the patent office, even while we searching, while I mean giving patentability searches also, there is always a chance that we miss some of the citations. So this is where like the patent watch by the inventors or the companies who are into business or who are into in that line, having inventions and having protection, and they try to market through revenues or royalties. So they have to be watching the patent office journal also, to search for their interested inventions, their inventions previously done or having rights, so that they can make an informed decision and then put forth if there are any conflicts through pre-grant oppositions to to the patent office, so that the overlapping application may not be granted on an error. So, or if it is granted also, we can still, for an year after the grant also, we have an option of post-grant opposition. We can definitely go to patent office saying like this is an error being happened without citing the certain citations 1, 2, 3. So with this, if these citations are considered, so this patent need to be revoked. If that is also crossed, then again there is an option to go to appellate body, which is High Court. There also we can ask for a rectification of the decision made by the patent office. So that means patent is not permanent. So if there is an error or if someone is overlapping our idea, so this is, I mean, the inventors or the applicant's responsibility to raise a flag and then and stop the other party to get the undue advantage of the known things.
Yeah, understood, sir. Thanks for clarifying it.
And but I mean, after the copyright thing, we'll Anyway, like we took some more time, but I'll try to complete what is patent, and we already discussed about trademarks and copyrights. And patents are exclusive rights for inventions that are new, involves an inventive step, and are having applications. We, as per Act, we call it as industrial applicability, but it is something like workability. It means workability. Like the patent office sees these three things. So whether they'll search and see whether it is new or not, and they'll see whether if there are some citations like the Gopi Garu is telling about the aspect one and aspect two combination of both. So that aspect is called the inventive step validation. Whether the patent office sees whether the claim is in proper format or overlapping the earlier existing patent, and it will direct the applicant to amend the claims such a way that invention one is not been claimed in their uh, independent claims. And then they'll also, in some cases, if they feel it is frivolous, or maybe if they feel it cannot be worked, the invention cannot be worked, that case during the examination, they'll ask for proof of an MVP or a prototype, so that like they want to understand whether this can be worked or not. If nothing is been provided by the applicants, then on basis of their doubt of non-working, or it is not capable of working, they may reject the application. And what can be patented? Obviously, products, processes, methods. It cannot be a business method. So means the idea of doing a business cannot be patented. But otherwise, if it is related to any field of science, um, apart from marketing, these aspects, business aspects. So it can be a product, can be patented. It means like the construction and working of it, the process of manufacturing, or maybe process of packaging also can be patented. And method of again methods of cleaning, or maybe preparing something, a drug or something, can also be patented, a compo along with the composition of it, if the composition is different and as well the method is different. What cannot be patented, there are examples of like there are a patent section under section 3 under Patent Act, so which elaboratively discussed about what cannot be patented, including the frivolous things, the mere discoveries, and the traditional knowledge that is already known in related to medicine or maybe food, and other aspects which are like barred as per the government, the local government, or maybe the government of India. Like gambling is barred in most of the states in India. So any machine related to playing of gambling, or playing of cards, playing of some kind of poker or something like that. So these are barred to give grants as patents for the technologies, because this again, if they are allowed to give patent protection, then that means like indirectly they are allowed to market. So for that reason, it is barred. And again, ammunition and national security related to arms, related to some technology related to drones. If the company or the applicant is not having a permission license to manufacture, then again the the examiners will ask for what is the basis, what is the, I mean, where you have got this knowledge. So what is the purpose? Whether you are actually starting a company now. So these questions will be again asked before giving a grant. And example, process patent, Pfizer's vaccine manufacturing process is patented under the process or the method we're talking. And mechanical inventions can be Dyson's bladeless fan is patented for the construction and working of it. And the abstract ideas, theories, business methods cannot be patented. Again, we discussed algorithms per se means like the known part of the internet, or maybe the computer related inventions. That means like the PPT itself, the presentation I made, and the way of making a presentation, maybe using ChatGPT, or way of manufacturing something using 3D printing cannot be patented, because like you have to follow the same steps, sequence of steps using that software. So the method itself, it can be for a different product. It can be for a monument of a elephant, or maybe a giraffe. So you cannot have a patent for a method of manufacturing of a zero of using 3D printing. So because 3D printer is designed such a way like the design can be anything. So it is made made using a 3D software, then sliced, printed into parts, or printed as one product after in different stages. This is known. This has been, I mean, it is the definition of or maybe the laid procedure to print using the machine itself. So they cannot be patented. And yes, duration is 20 years from filing date if it is granted. And publication of application date is not considered as a date of publication. I mean, for the duration calculation, but for the damages calculation, it is date of publication is the date to be date the courts will take for consideration of damages in case of an infringement. But otherwise, for the duration of the patent, it is 20 years, and there is a aspect of filing improvement patents or depend in division of patent applications. For example, if we have discussed 3 or 4 aspects of combining the different power sources using, I mean, again combining with a regenerative braking concept or something like that, and then in that case, like all of them filed as one invention in one application, the patent office may ask during the examination to divide the applications into multiple based on the inventive steps if they have novelty. Each inventive step, if they have novelty, then the patent office will ask us to divide the applications. And in that case, like with the same priority date, means filing date, we'll get multiple patent grants if they prove, if we can prove the inventiveness. And without grant, it cannot be enforced. So any right, even the trademark, as per Trademark Act, Copyright Act, and Patent Act. So with only after filing, you cannot actually sue, or we can definitely ask by sending cease and desist notices saying like we are already doing this and we have a prior usage. We can tell that and ask the other party to stop infringing it, but we cannot enforce through a suit or through going to a police station with a formal complaint saying like I'm having a registration, because yeah, the registration has to happen after validation. And novelty check, yeah, it's again it's a myth, like or the inventors think like it is new. Uh, it should not be publicly disclosed before filing an application. That is what novelty is, very simply. Means we cannot publish and then, or we cannot start using it, and then after 2 years or 3 years or 5 years, we can go to patent office or design office to ask for a registration for a patent grant. In trademark cases, like we can definitely start using the brand because trademark registration is not mandatory or a license. After use or after some time after use, or even after 10 years, 20 years also, we can go to trademark office, show our uses from last 10, 20 years, and then ask, though the application date is current date, but we can ask for a registration from the previous date that we are started using it. Not in patent cases, not in design cases. Copyright also, after publication, you cannot get a right, but defaultly you'll get a right. So copyright application has that provision. We can mention whether it is published or not. If it is published, we can mention it as it is published in so and so year. Date is not important. The year is important. So the difference, brand versus product, simple. Both are same. Product name is the brand name, or the company name is the brand name. In some cases, we can say like trade dress or trade name and brand name. Trade name is the business name, and the product name is the brand name or the trade dress. So trademark protects your brand name or logo, while patents protect the product's technical features or new solutions when we compare with patent and trademark. And what is the difference between the content and idea? Um, Copyright protects the expression like a book or code, while patents protect the underlying innovative idea or method. But again, not the mere idea. And we'll take some examples. Slide, yeah. For a clothing brand, trademark protects name, logo, like Fab India. Copyright protects the photo shoots, and patents protect new fabric blends if invented. If there is a new blend of fabric being manufactured by Fab India, then in that case, like Fab India can actually file a patent for the process or the method of doing it. So we filed a patent for ICAT. So it is not right filing. So we informed the applicant, but why I'm telling it's not a right filing is because ICAT is already known. ICAT is I mean it's a GI, Pochampally. But the thing is like they had a machine supplement for the way like the manual doing of the ICAT. So that machine is not completely automatic. It is a semi-automatic thing, means like holding the yarns before actually they are dipping into the colors and then drying it. So it's obviously an invention, but again, it can be protected as a design registration. We filed a design also. We got a design registration, but we filed an utility patent also, but we failed to get a grant because it's again it's not a machine on automatic mode. It's a tool that helps the ikat way of uh, weaving the clothes, mainly the dyeing part before weaving it. So the utility wise, like the examiner feel it is obvious, means like it can be a tool, but it cannot be an utility model for a patent grant. And another example, it can be an app for a startup, for an app. Trademark protects app name, logo. Copyright protects code and UI design. Patent protects unique algorithms or technical solutions developed. I want to give an example here, like Myntra uses a feature. I don't know whether it has been licensed by Myntra or been protected by Myntra, but there is a feature after we select the products into our wish list, and then we revisit the wish list page. So the beneath the each product that we have had it in that bucket, like it will show like how many products are left in the inventory. That is obvious, but it will show how many people are actually along with us viewing that page, that product into their wish list. So this is something like actually it is converting the interest into sale. This aspect of it can be patented, and I believe like they patented it, and we have other examples in for like patented by Uber. So their spotlight feature, when we are actually waiting for a cab, searching for the number plates, and there is a feature under the trip details, like we can spotlight, take that option of spotlight, and our screen of the mobile, like it will show a color which can be identified by the cab driver who is actually approaching us. So in a case of where we are standing at a railway station, bus stand, or maybe airport, though we are allowed to book it 5 minutes earlier, maybe 1 hour before actually boarding the flight, or maybe before we waking up, when we are actually trying to go pre-book and go to airport early morning. But the spotlight helps us actually. There is a problem we have even after the technology gave us that flexibility to book, and the cab will arrive in time. But there is a problem that we have to search for the number plates when there are multiple cabs and multiple users at one place. So for that, like the Uber had this spotlight, very small aspect in their development, but this can be an invention, and this is a patented thing, that feature. And quick comparison, trademarks for the brand identity, copyright for creative works, and patents for inventions and technical solutions. It can be a small thing within your thing, which is not obvious. Apart from the obvious things that we have, like we had it in like in the Uber or the Myntra or in Amazon. So the cost comparison, I just want to show trademark, the government fees is 4,500 for small entities and startups and natural persons. Actually, it is 9,000, but it is subsidized for small entities, startups, and natural persons. 9,000 is the fee for larger entities. This is for one class, and there are 45 classes. And if someone wants to file in 45 classes for all the services, all the products, they are planning a big brand, then they can actually, will suggest like they file it stage wise in the classes that they wish to use it initially, and then the next level. Or they can file all the applications. Like there is a multi-class application, they can file one application, but they have to pay again anyway the fee independently for each class. Or they can file individual applications. This will help in case of multi-class application. If one class the examiner has objection, then the whole application should wait for clarity on that class. So it is suggested to file individual applications in case like there are multi-class applications. And copyright, it is 500 rupees for the literature works. The government fee for the sound recording, it is the 2,000. And for trademark applications, like for the logo applications after trademark also, it is 2,000, not 500. So it is considered as artistic work which is being used along with the product. But otherwise, the normal artistic works like an art, so it can be protected with fee 500 rupees. And there is another category which is the fee is 5,000 for each title, which is the video recordings or the cinematographic films. That is the category. And for patent applications, it's again approximately 20,000. Why I'm telling this is like for normal case, it is 8,100, including a early publication. 1,600 is the application fee, 2,500 is the early publication fee, 4,000 is the government fee for examination. And there is an early examination of additional 4,000 for startups and small entities and women applicants. And apart from this 12,100, the mandatory fees, including the early publication and early examination. The gap of 12 between 20 is that like during the examination, there could be some fee like that for the amendment for whatnot, like for any petitions. So an approximate cost of 20,000 is the government fee for patent end to end. So for trademarks, again, like end to end, it is 4,500 or 9,000. But again, in trademarks also, if there is an amendment that we want to make for the address or for the goods description we want to change, then there is a fee of 900. Corporate, there is no additional fee. So this is what they will charge. And based on this, they'll decide whether to give a registration or not. The percentage of registrability in corporate applications, if there is on face of it, there is no, if the application is clear for artist, for work, for artistic work, we file artistic work application. For literature work, we file literature work application. For sound recording, we file sound recording application with a brief description. So there won't be additional fee, and registration will be 100% almost. I never saw a corporate application refused because they won't validate the content. For trademarks, they will validate. For that reason, the percentage of registration, again, it depends on the search, the quality. So we need to search across the classes, dependent classes. For example, food product, if someone wants to protect dairy products like milk and milk products, which falls in class 29. And again, they want to have some more brands like paneer or maybe some cooked products packed, ready to use, ready to cook. So these products falls under class 30. And if they are having some fresh fruits or vegetables, again, that falls under class 31. So there are multi-classes, but while we register in 29, we need to check in 30 as well, 31, because like down the line, we have that plan of having other product ranges as well in the food category. So for that reason, we need to search in the dependent classes also, 30 and 31, when we are actually filing in 29. The same way for technology services, we need to search for class 35 for the platforms. So normally technology service is 42, but if it is through a website or an app, it is again 35. So we have to register in both the classes, or we have to at least register in 42, and the second application could be after some time in class 35. But while filing the first application in 42, we need to search in both the classes. So that's it. Common myths are copyright protects brand names, false. So it need to be filed as a trademark application. And patent registration protects brand. No, it need to be filed as a trademark application. So patent registration or patent application is for technology part. And trademark protects brand design. No, there is an application for as a shape of the good, but normally the design of the product, the outer shape of the product goes under design registration. And final slide, trademark is for brand, copyright is for creativity or creative work, and patent is for innovation or the implementation of the idea in the form of technology or a product, or it can be a process also. So
Yeah.
contact us to protect your IP today. And this is Srinivas Madhupati signing off with permission from Raj Misa.
No, sir, this is
Okay.
great. In fact, no, the entire 2 hours, people spend 2 hours on a movie just for the storytelling aspect and all, but for beginners, mainly for interns or for people who are asking. Now, I know in LinkedIn we get lots of DMs saying, is there an intern opportunity where we want to learn the basics of IPR? I guess this will be the best resource which I can send them. Not everybody can sit and go through it. Thank you, Gopi Garu, for all your patience, for still hanging on.
Yeah, it was with loaded with a lot of information and got clarity for many of the applications. So, like, thanks for doing it, Eva services again. And this is my first session, but very helpful. Thanks, everyone.
Thanks for joining. And do please sign in every Wednesday, 11:30. If you have
Yeah, and quick one. So Swati, is she from Eeva team or Swati? Could you please unmute and speak because you were there for quite a long time here. Just wanted to hear. Is she from our team, sir? Or
I think like she's our team. Like
okay, cool.
yes.
So, but thank you, sir. Again, only thing is probably you should gulp a little water in between because I didn't see you sipping any water for last 2 hours. But thank you, sir. I'll make sure this will be a available resource for everybody out there. Mainly all those interns who are asking, and for we can also have also recorded it apart from the live stream onto YouTube. We've also recorded it again. We'll share it as shorts or reels for other people as a snackable bites. So I'm shocked that Uradi Rajeshwar Prasad Garu spent hundreds of patent applications with 20,000 government fee. I'm shocked when I saw that slide, but we will stay in touch. So tune in for next Wednesday for the same set of live webinar series.
Yeah,
Thank you.
he filed 147, I guess, by now or more. Like he'll give a surprise every week. So he keeps on filing at least one application every week. And like he got 80 plus grants.
So does
Yes,
it?
out of his pocket, like till now, like he's filing the applications. Like he'll file with early publication. That means like he'll pay, and also the pages wise, drawings wise, there will be more number of pages apart from 30 pages, what is allowed normally. So he'll pay at least um, around 7,000 each application, approximately. So 150 applications into 7,000. And again, 80 plus patent grants till date, like he is paying renewal fee every year for all those grants.
Wow.
So
He asked me not to
is
start promoting him. When we saw that group picture, he did ask not to promote him or bring him to limelight because I wanted to. Because in Telugu states, for sure, in South India, there's nobody, as per my knowledge, who can beat his numbers as of now, apart from the Japanese guy who had thousands of patent applications. But moment he gives me a green signal, I wish to start promoting, not because he's from Warangal or he's from Telangana, but again, as
we
another
are
Telugu.
starting this marketplace, like it's not marketplace, like I had a separate domain, but I mean, we are in still actually deciding on where to host these patent granted patents, which are open to commercialization. Like we got approval from Chandrasekhar Garu and like lot many. So we had at least 50 approvals till date. Like we want to put it on to the website, and then we want to promote also through other social pages with your help. Yeah, let us see. Like we may waiting for a right moment, date. It can be August 15th also. But yeah, very soon.
Okay. Thank you, sir.
I'm
Thank you, everybody.
requesting, yes, Voradi Gari would also, so that like we can actually start promoting it. Though he is into employment with state government, there is no bar for him, because like he had a permission from Chief Minister then in 2009 or 9 itself,
Wow.
for working on different ideas which are not conflicting his area of work. Yeah,
Yeah.
like we will be, he'll come to limelight, and the mainly the granted patents gets commercialized in, because they are into power, solar and other different power, regenerative power generation.
And I wish he's going to write patent agent exam like the way Sai Krishna did. There's no surprise if he lands Uradi Patent Services mainly in Warangal. But thank you, sir. So we'll stay in touch, and you may catch the